Good afternoon, everyone. Well, we have this fantastic panel here. Maria Nizera, who's written the paper that we're basing tonight's discussion on. Kennedy Talbot, KC, who is, I've sat behind on many occasions in court as he valiantly tries to recover money from people with sometimes success, other times it takes some time, and he's still working hard to do so, but very experienced in understanding exactly how the legislation that we have at the moment works. And then Helen Taylor from Spotlight on Corruption, who looks very closely at this issue as well, and follows lots of cases, and again has observed and written about the challenges that are faced using the existing mechanisms to recover illicit assets. Clearly, as Helen has just said, the big challenge that's been thrown into focus by the Russian conflict, the Ukraine conflict, is how do we seize all these assets if indeed it's desirable, and how do we do so if that is desirable without, when it may not be easy or possible at all to prove a criminal origin of the assets, you're targeting some people who are sanctioned for political reasons, and how do you then develop an effective mechanism for seizing those assets which does not take this country down the road of arbitrary confiscation of the sort that might be carried out in the very sort of regimes that we're trying to target as a result of the measures that are being deployed. Perhaps first of all, Maria could talk to us about what the freeze to seize dilemma is, how it exactly manifests itself, and a little bit of an outline of your paper, which we'll then come on to discuss in greater detail.
Sure, thanks, Martin. Thank you for being here also, and I wanted to thank personally Helen and Kennedy for being here, and also you guys to come and basically fight the event fatigue that I know we're all feeling at the end of this year that has been quite intense. So yes, why it has been intense, especially as we talk about financial crime and illicit finance. Russia invasion of Ukraine back in February 2022, it has definitely resulted in two things mainly. One, in an unprecedented response as it relates to coordinated sanctions rolled out against individuals and entities linked to the Kremlin, and at the same time in a sort of unprecedented realization from UK, and not only UK, policymakers of the impact, the security impact that dirty money had in the country and also elsewhere for such a long time. The realization that for such a long time we had vulnerabilities in our system that we had not properly addressed, which meant that individuals that are also currently designated under Russia sanctions had basically exploited and therefore bringing our dirty money into this country by buying properties, buying assets, and just generally speaking, laundering the proceeds of, I have to say, their alleged historical corruption. So when we talk about freeze to seize, and I think that this is the start of my research, the paper that you mentioned, which is still not published because it is an ongoing research that is going to come out finally in mid-December. But it is the result of 9 months of me researching and talking with experts after experts, legal protection practitioners, members of the academia, policymakers as well. Practitioners such as Kennedy, legal researchers such as Helen have contributed massively. So I'm very happy that they're here today, because they're definitely going to explain the legalese stuff better than me. But so my research has focused on this matter of freeze to seize. What does it mean? With Russia's invasion of Ukraine, policymakers in the UK are facing a dilemma. On the one hand, they do want to hold the so-called oligarchs, individuals, currently under sanctions, accountable for the actions that the Kremlin in Russia is committing in Ukraine. So basically pursuing a foreign policy goal. And this is what the origin, of sanctions. Sanctions are a political tool that is serving a foreign policy purpose. So we have this goal on one side, but at the same time, we have oligarchs, which, as the name suggests, potentially, they do belong to a specific category of individuals whose wealth was allegedly, again, accumulated back in the 90s and is the result of corruption or corrupt dealings, and they still are profiting from patronage, from some sort of let's say linkages to power in Russia, and they still hold, at least according to the view of UK policymaker, a specific influence over the Kremlin. So what happens now? We have these oligarchs that are currently under sanctions, and the idea is we want to show our support to Ukraine. At the same time, we want to also show that dirty money has no place in the UK. So some policymakers, some MPs we probably heard, especially at the beginning of the war, we were talking about grabbing the assets and housing Ukrainian refugees in the houses of the oligarchs. Then we have MPs showing in front of yachts and saying that we had successfully seized and confiscated that yacht. That was not true, that these assets, as they are currently under sanctions, they can only freeze the assets, they cannot seize, they cannot confiscate. And if we actually want to move from freeze to seize, sanctions are not the answer. Sanctions, as I said, are a political tool. They provide an asset freeze that is supposed to be temporary. Being a foreign policy tool, the goal is to change a behavior. If we want to go after the assets, then we are going after a crime. And therefore, we're talking about proceeds of crime, and we're talking about Proceeds of Crime Act and lengthier due process, human rights compliant mechanisms. We cannot just grab people's assets. We need to, there's something called property rights, there's something called due process that we need to respect. And that came with a challenge. The UK asset recovery mechanisms, we got some, but they're not simply up to the task to do so. And I'm sure that Kennedy is going to talk more about this.
Yes, maybe we could ask Kennedy, because Kennedy is the person who's experienced this and heads of chambers of people involved in this type of work. Could you explain, Kennedy, what we have obviously unexplained wealth orders, account forfeiture orders, civil recovery powers, confiscation orders for criminal people convicted of criminal offences, a whole panoply of different bits of legislation, different powers. Kennedy knows very well that they work to limited effect. Perhaps you can explain what the challenges are and why they may only be of limited use in tackling the sort of problems that Maria is talking about.
Yes, of course. Well, first, thank you very much for inviting me. I should explain, as everybody has implied, I'm a lawyer in independent practice, so I act for all people who are involved in this kind of area, not just government, but companies and individuals who are caught up in these laws. I have no skin in this game. I'm not retained in any way to promote anybody's interests. What I'm trying to do, I hope, is to provide as much technical expertise as is possible to ensure that anything that is promoted or recommended works, and it works in a way which is theoretically sound, compliant, as Martin said, with the rule of law and international standards, and is practical, being at the end of this, once in the end someone has enacted this. I should say also, from a personal perspective, that as well as doing this piece of work for everyone, of which I'm exceptionally proud, the other main piece of work that I'm doing at the moment is for an NGO, and it relates to making financial institutions, high street banks, responsible in money laundering for the deforestation of the Amazonian basin. So single-handedly, I think I'm bringing the war in Ukraine to an end and ensuring we meet the Paris target of 1.5 degrees and solve climate change. I'm hoping to get that done by the end of Friday. So yes, to get then to the point, lawyers never get to the point, do they? The point of the question. Well, I think everybody broadly understands the regime that we've got. If we're looking at this from a proceeds of crime angle, we have an act called the Proceeds of Crime Act, which, as you know, only enables the proceeds of crime, particular things that represent the proceeds of crime, or the value of the proceeds of crime, to be confiscated. And that plainly has its limitations if there is an issue as to whether or not a particular asset is the proceeds of crime, or whether people have taken in the proceeds of crime. First, the criminal laws. The most likely prosecution that one might see is obviously one for money laundering, since the assets are likely to be in this jurisdiction, or the arrangements in this jurisdiction. Money laundering is what they call a criminal lifestyle offence, which is actually quite important because it links to one of the other topics that we'll come on to shortly. And that means that if a defendant is convicted of any money laundering offence, however trivial, the burden then shifts to the defendant, the reverse burden principle, to demonstrate that all his current assets that he currently holds and all assets passing through his hands are the proceeds of crime. And if he can't do that, the court calculates the value of those and they're added to his liability, which can then be satisfied out of any of his assets, whether they're the proceeds of crime or not. So that sounds great, doesn't it, in practice? So how does that relate to the type of cases that we're looking at? Well, firstly, you have to get someone convicted, and the person you have to get convicted is the person who holds the property interests in the property you're ultimately trying to confiscate, which itself can represent a difficulty. We're all familiar with the kind of corporate structures and opaque vehicles that one often sees in these type of cases. You have to prove that the property that you're looking at in respect of the money laundering allegation, remember you have to get a conviction, is in fact the proceeds of a particular type of crime. You don't have to prove individual crimes, but you have to prove a type, and you can put it fraud, corruption, other crime types that are recognized in English law. Self-evidently, in these cases, you're going to need evidence from overseas. And it's very likely in these sorts of cases that you're faced with an uncooperative jurisdiction who won't provide it. Next is the key point, which to my mind is the key issue, that if you don't take anything away from today, from my perspective, that you need to take this away. And it says, as was said earlier, when you're looking at these people's assets, these targets who we're thinking of, the oligarchs and the so-called kleptocrats, very often their wealth originates from activity which took place 35 years ago in the early 1990s. Now, I have seen a number of allegations relating to kleptocracy and corruption and so on, and these reports with great intention circulate on the internet and then get repeated and re-repeated, and then it looks like there's a strong case in relation to kleptocracy or corruption at the time. But I've never seen a convincing case that an individual's assets can in fact be traced back to any kind of forensic standard, to any kind of activity which is other than privatization of what was previously nationalized industries, mainly, but not exclusively, natural resources. So that's a big problem. It's not a question of there's something wrong with the laws or there's something wrong with the evidence gathering, it's that it didn't happen.
Yes, exactly. So the criminal, and just explain on the civil side as well, because obviously there's civil powers, the same problem effectively prevails there, doesn't it? Because although you don't require the criminal conviction, a degree of proof is still required that the money has a criminal origin of some sort. So you get civil recovery, for example, and explain wealth orders is another example where it's not just a straightforward case, is it, as you will, I hope, clarify, that you can just go and say, this money was obtained illegally, and the court says, yes, that's fine,
yes.
And that's it. So,
and the reverse burden of proof, which I was speaking of, doesn't help. Just to finish off the criminal before moving on to the civil, very, very quickly, the reverse burden of proof doesn't help, because you say, here's a yacht, here's a house in Belgravia, here's a company which owns a string of subsidiaries and the shares are worth millions of pounds. How did you get it? He says, I got it from privatization in the early 1990s. And right, prove it. And he comes up with a bunch of lawyers and accountants who say so. And on the whole, what they say looks pretty convincing. And there can be no complaint that they may not necessarily have the records and the documents to prove it, which is normally what is required in these cases. So it goes back so far, you wouldn't expect them to exist. So then moving, so it really doesn't work, these kind of cases, from a criminal perspective. Neither does it work, largely, for the same reasons for a civil perspective. Civil perspective, you have to identify a particular asset which exists at the moment. In the case of account freezing and forfeiture orders, it's obviously a bank account, but there are broader powers in relation to any type of assets in the same part of the legislation. But you have to prove that particular asset is, directly or indirectly, in whole or in part, representative of conduct which is a crime, or would be a crime if it occurred here, if it occurred outside the UK. And again, that's a burden that the applicant has to bear, and you have the same problems that I've just identified: evidence overseas, such a long time period, difficulties with obtaining the material. All those things make it very difficult.
Which, of course, just to finish the point, we'll ask Helen in a second to come in with her observations, but clearly it gives some indication as to why the Russian oligarchs, for example, who are in this country, who allegedly are beneficiaries of this kleptocratic regime 35 years ago, have not been targeted previously, because clearly they could have been using existing legislation. So, and that the problems that Kennedy has identified there would be at least part of the explanation for that. Helen, would you like to?
Perfect, happy to come in here. And again, thank you so much for inviting me to participate in this discussion, and thanks everyone for attending. I think it's very easy to get bogged down in the difficulties, and they are, I think, very, very serious challenges that I think we've already set out, but we'll come to in more detail. I'd like to start on a more positive note, I think, which is to remember in a way where we've come from, which is that, at least in the UK, as Kennedy's outlined, it's pretty uncontroversial to recover assets on the basis that there hasn't been a criminal conviction. So we've already moved from at least an exclusive focus on the criminal conduct to looking at the property itself. Obviously, there are limitations. Kennedy's set those out. It's clearly there are constraints, particularly when we're trying to target historic corruption, that at least appears to be very legitimate in its origins. But just to remember, we have come from there. And the question now is, where do we go from here? Where next? And in doing that, I think there are many, many different avenues to explore. Of course, at the one extreme, as we'll talk about perhaps in more detail, and Maria's alluded to, there's sanctions-based confiscation, and I think there may be serious problems with that. But there are many other avenues. We can look at expanding the definition of recoverable property to somehow capture the proceeds of kleptocracy, given the constraints that Kennedy's outlined. There are a number of options, and I think just as a preliminary point, I'd like to make a couple of observations about what I think are the parameters, or two key parameters that should guide our thinking as we look to what new tools could look like. The first is that I think any reforms or any new mechanism needs to be legally sound. And I think Maria said this perfectly well up front. We have to ensure that whatever new tool we craft, whatever reforms we implement, are going to hold up in court. They have to uphold the rule of law. They have to be proportionate as an interference with property rights. There need to be due process protections. And I think we can all agree on that. Certainly, I think on the panel, we've discussed it. I think we agreed. But the second thing I think we need to think about, and it's perhaps sort of easier to forget sometimes, is that we also need to be strategically savvy about the new tools that we're looking to craft. We have to look at how new tools would fit within an existing toolkit that law enforcement use, and what is likely to be sort of in practice really effective from an enforcement point of view. I think one of the lessons we learned from UWO is that we can have a very shiny new tool that looks very impressive in the box, but take it out and perhaps we find it's a bit unwieldy in practice. Perhaps there are unforeseen difficulties, procedural and practical obstacles that can kind of hinder the effectiveness of those tools. And I think we need to look, therefore, at the issue of freeze to seize in a kind of a bigger picture of what is the whole system response that the UK is putting together as a system in response to kleptocracy and tackling the problem of dirty money that I think Russia's renewed invasion of Ukraine has really brought home for us. So those are just by way of beginning, perhaps, as the parameters to bear in mind.
Thank you, Helen. Maria, that brings us on to your paper. And you've looked at 5 countries, I think Italy, Switzerland, Ireland, Canada, and Australia. Different examples of legislation that have been passed in those countries, attempting to address variants, at least, of this problem. Would you like to just, and you highlight particularly, I think, the Italian and the Swiss models as offering perhaps the greatest lessons, but would you like to just tell the audience why you think those two models are the most promising, and what are the lessons we can learn from the international legislation that is out there?
Yeah, sure. So first of all, talking about my research, I always say that I looked at every possible asset recovery mechanism from Austria to Zimbabwe, because again, there was the idea, once understood that the UK mechanisms were facing specific challenges, then let's see if there are other countries that are doing better and how. And so the first answer is no country is doing great when dealing with proceeds of grand corruption, kleptocracy. I really don't like the term kleptocracy, but you understand the type of crime that I'm talking about, anything that is complex, transnational in nature, and that presents all the challenges that Kennedy has properly outlined. So once we know that no country is doing better, now I'm going to be a bit Orwellian. All countries are equally bad, but some countries are better than others as it relates to dealing with asset recovery mechanisms in general. And not to brag, I mean, Italian born and bred, so obviously the first country to look at was back home. And Italy has done surprisingly well as it relates to asset recovery mechanisms and asset recovery rates. We're definitely going to talk a bit more about why the Italian model is more successful, because it's not just about the law, and what Helen said about the whole of the system response is absolutely crucial when we talk about the response that we're trying to plan as it relates to the oligarchs and the kleptocracy in general. But the Italian model and the Swiss model, they do provide something that I think is definitely missing in the UK, and that is the sound understanding of what I said at the beginning, which is the societal danger and the national security impact that corruption or dirty money, whatever you want to call it, has on a country. So the Italian models, for instance, it includes, it does not have civil, which is, okay, interesting in itself, but because they don't have civil, they have gone through an administrative measures, and they have come up with this sort of preventative confiscation model, given that they were facing the same exact problems that Kennedy has highlighted when dealing with mafia members. And if there is one thing that the Italians know best, is that it doesn't really matter to convict the individual. The mafia boss is going to, lead their clan, do their life from prison with no problem. What really hurts is getting those assets. Okay, so once got that, preventative measures in the Italian system, in the anti-mafia code, they have this incredible idea of that they target an asset owner based on the dangerousness that this individual represents to society. Dangerousness can be defined both in a generic and in a specific way. So obviously when tested in court, you need to typify the criminal conduct in a way. But the first article of the anti-mafia code, I have it here translated from Italian, so apologies if it's not proper legalese, but it says that essentially there needs the possibility of an individual of carrying out in the future conducts that disturb the social, economic, or constitutional order of the Italian state. And how do we define that? Because maybe they had a previous conviction. Their lifestyle suggests that as they consort with other mafia members, for instance, makes it likely that they are benefiting from criminal activity and that their money is, the assets are somehow related to proceeds of crime. And then finally, again, that those that they have this conduct somehow because of their it's not really, it's because of this dangerousness, the danger that represents society, it is worth to go after and pursue these assets. And Switzerland, I'm going to be very quick, like obviously not going into the details, read the paper whenever it's going to be out, but Switzerland has a very similar thing. Although they do have caveats, and obviously you need to test it in court, and they need to go and typify the conducts, what they do is highlighting the dangerousness of this money, and therefore, if we were to apply to the UK, we have to bring this into the legislation. For instance, what Helen suggested about changing the definition of unlawful conduct, for instance, as to relates to something that undermines the national security, or even just, it is linked to the consortium. But I think that this is the main point of those systems. And generally speaking, and I'm gonna probably talk more later on, I think that there's it's the understanding and therefore the appropriate whole of a system response that a country like Italy has. So it's not just the law, and I think we're going to discuss it a bit later on that.
Kennedy, what do you make of the different international examples and the practicality of using those, and desirability of using those in this country?
Well, I mean, plainly, Italy's experience reflects the economic and criminal challenges which pertained in Italy, and the laws are traceable back to the mid-1950s, and so they've got a long experience of being able to administer them and work out what actually can work. I can see quite readily that you could, for example, amend the Proceeds of Crime Act so that you made provision for future intended use of property as a basis for it being forfeited. As it happens, one already has that in relation to the account forfeiture part. If it's intended for use in crime, then it's already liable to forfeiture. And that expression seems to me to be quite broad and probably narrower than simply a danger to the operation of constitutional position of constitutional order or social order in Italy. But one could do something like that. But I still think it comes down to, in the end, getting some evidence to build up a case that you've got more than just somebody who's made a lot of money out of privatization and has some links to a regime with which this country is not on good terms with, whether it's because it's invaded Ukraine or whatever. And when it's still left, then even if one has that, and I don't want to trespass into the next area, which is perhaps the most important thing, you can still only forfeit property if it's human rights compliant. And you have a real problem taking assets of large value away from individuals, the citizens, on the basis of a tendentious link to Putin or to the legitimate goals which one could specify in the legislation, as Maria has outlined, Italy does.
Yes. And any other the international examples that you think overcome that in any way or not, or is it a challenge for all of the different ones? Very quickly, and then we'll ask Helen
Yes.
to...
Well, the interesting thing is that all of these examples that Maria has unearthed still revolve around, apart from the Canadian example, which isn't tested yet, still revolve around the idea of linking this property in some way to criminality. And if that is what we are going to do, then we are going to continue to have the problems which I outlined at the beginning. Yes, we're going to broaden the net, we may capture more, we may make it easier to prove forfeitures, or seizing as you call it. But fundamentally, it's not going to address the issue that everybody is really concerned about. It's not going to make the slightest bit of difference to recoveries, its effect on Putin, making any reparations to Ukrainians, or financing their armed conflict.
Right, Helen, you introduced a note of optimism to last time round. Can you do
try
it
and
again this
remain
time?
optimistic. Yes,
what
I'll
do you
try and
see as...
remain. Well, perhaps to begin with just the shift to the focus in the Swiss and Italian model on social harm and damage. And I think, you know, the whole freeze to seize debate has arisen within the context of how can we confiscate and repurpose assets to rebuild Ukraine? I mean, that's a lot of the driving motivation, I think, behind this debate. Whether we think that's the best way of going about it or not is different, but I think that's the driving force. And this shift to focus on the social harm and the damage, I think is quite useful for thinking about, you know, who are the victims of kleptocracy. And I think that's quite a useful shift. Also, similarly, the focus on national security, which in the Italian context is quite particular, of course, I think that's very helpful, given that, once again, Russia's renewed invasion has really brought home the national security risks, not in terms of what's happening in Ukraine, but really on our doorstep. The national security risks for the UK, the integrity of our financial systems, the integrity of our political systems, in terms of, you know, the lack of checks on political donations, for instance. And I think it's really brought home that the UK has a problem with dirty money, and I think so focusing on the national security risks, I think, is a very constructive one. Perhaps turning to some of the details, like Maria, I'm quite drawn to the focus in both the Swiss and Italian models on the networks and the associations rather than individuals necessarily. I think that's quite helpful and is perhaps the right direction to move in. I think one drawback, it seems, particularly in the Swiss model, is that it seems limited to past office bearers rather than sort of present incumbents, and I think that's quite a limitation. Potentially, certainly in the UWO context in the UK, we've felt that. For instance, the Hagieva UWO, which, Martin, you know a lot about these, having covered them, but you know that arguably was a lot easier because you're targeting someone who's really fallen out of favor with the regime and in fact fallen into prison, so that makes things a lot easier. But the Aliyev UWO, you know, that's targeting someone, you know, where they still enjoy, you know, quite a lot of favor and benefits from a regime. So it's more difficult. So I think that's one of the shortcomings. Perhaps in terms of other international models, to be creative and optimistic, I would point to my home country, South Africa, that has a very interesting regime around racketeering. So the racketeering itself isn't an offense, but it's an offense to be associated with a racketeering enterprise, which is defined very, very broadly. And, you know, I think really targets networks of patronage. It focuses on the interpersonal relationships rather than individual transactions. So, for instance, it allows the court to convict on the basis of having participated in the enterprise rather than necessarily having received property derived through that enterprise. It's much broader and potentially could be a very helpful way of targeting. I know, certainly speaking to investigators and prosecutors,
It's had a lot of benefits procedurally in targeting networks that are otherwise kind of hard to really particularly get to the kingpins, people who perhaps call the shots but keep their hands clean while intermediaries do the work. So I think, you know, there's a lot of inspiration to be drawn from other countries that have tested things, and I think we should not be afraid to try out new tools within the constraints that I've kind of pointed out earlier about thinking of it within the existing toolkit that we have and making sure that they're legally sound.
Yes, just in passing, no money has been recovered on the Hajieva UWO yet,
Exactly.
despite nearly 5 years on. This is the woman, if anybody isn't aware of the case, who spent £60 million at Harrods, very entertaining for us journalists, but still no money has been recovered, which obviously illustrates part of the problems with that piece of legislation. Maria, your paper talks about reversing the burden of proof as a possible way of trying to attack this problem. Could you say a bit more about that, and perhaps Kennedy and Helen can say whether they think it would actually achieve anything? I think I've heard Kennedy's.
I think I'm gonna, yeah, exactly. I think I'm gonna let Kennedy first speak on this, and then I will.
Kennedy, would it?
Yeah,
would it
well,
work?
there's two issues in relation to this. The first, you have to have a set of facts which justify a reverse burden. And an example which one sees frequently in legislation, although we don't have it, is where you have a disparity between declared income and apparent wealth, and then the target has to explain how he acquired the difference. And there are other examples. PEPs who've got more than their salaries, their national salaries, would appear to justify. But it goes back to really to what I said at the beginning, where there are these reverse burdens of proof, and even when there are not reverse burdens of proof, because of the nature of these cases, the targets just wheel out accountants and lawyers to produce reports and opinions and file documents in various corporate houses across the world in order to demonstrate back as far as the court might think they reasonably can the legitimacy of this of these funds. And that becomes almost impossible if you're the acting for the authorities to counteract. And if you've got nothing against it, then the target will win the case. In the end, the burden of proof, all that means, the reverse burden of proof, all that means is if the court can't decide who is right and who is wrong, the person with the burden of proof loses. So in all cases, whichever side the burden of proof is on, it's always down to the target to provide an explanation. If it's accepted, he's in the clear. If it's not accepted, his assets get forfeited. So the reverse burden of proof doesn't, I think, make a lot of difference, except arguably in some cases at the margins.
Any thoughts?
Yeah, I mean, I think it's not a silver bullet, and we shouldn't frame it in those terms, but I do think it can help address a kind of information asymmetry, if you like. So the fact that the information and evidence that's required, often very hard to get from uncooperative jurisdictions, for instance, is really in the possession of one party, sometimes almost exclusively, but not the other, law enforcement. And I think in a way the reverse burden can at least help level the playing field to a certain extent, although, you know, as Kennedy said, one still has to make out the case in the end, and that could be difficult. So I don't think it's a silver bullet, but I do think it can tip the scales in a way that can be helpful in addressing some of the evidential shortcomings. Just to point out to another comparative inspiration, perhaps, Jersey's forfeiture law, I think is very interesting. It's sort of like a beefed up version of our AFOs, where it uses the SARS regime as essentially a gateway into confiscation by reversing the burden once a consent request has been refused. So it immediately sort of opens up a forfeiture process that is almost automated, and I think, you know, on the basis of a reverse burden, I think that can be, you know, it's very strong. I'd be interested in Kennedy's views on that, but I, you know, definitely think it's progress, but it's not going to solve all the problems. But again, I would say we need to think of this together with other mechanisms and reforms as a whole system response.
Kennedy's views on this?
Yeah, I mean, that's it's an example of a set of circumstances which justify the burden being reversed, but it doesn't get you over the ultimate hurdle, as Helen says, which is, in the end, if you're the state, you've got to put forward a credible case. If that's accepted, you're all right. And in the end, if you're the target, you've got to put forward an acceptable explanation. And if it's not all right, then your assets get forfeited. So where the burden lies doesn't really matter too much.
If I may add, so I think that, again, it's quite of a, Do you know, especially from policymakers, there has been this idea that changing the law, you know, for instance, introducing just full reverse burden of proof, because right now the UWOs are not really a full reverse burden of proof. They are an investigative tool, not a standalone mechanism. So that already presents in itself some challenges. But again, it's not just by tweaking the law that we're going to solve this problem. And as Helen said, it's a matter of, you know, bringing the odds more in favor of law enforcement and bringing these cases to court. What happens is there are several issues that needs to be tackled right now, and we need a whole of a system approach. Changing the law, whatever it is, proceeds of crime, or as some other people might suggest, some like the Sanction Act, it brings you so far. So the law, if it's not properly enforced, it's just going to be a nice piece of paper. So I think that, yes, reverse burden of proof coupled with other reforms that look at the three pillars essentially of what is a basic response to illicit finance, which is enforcement, regulation, and then legislation. That's when you bring the odds more in your favor. And obviously there's going to be, you know, that kleptocrat that is going to escape the law, but at the same time, you're giving law enforcement more tools in their arsenal to go after those proceeds of crime. We're not going to get them all, but, you know, at least something better than what we're doing now. That's my point. And I think that what I was saying about Italy, for instance, talking about resources, obviously Italy has faced a challenge that it's very different from the one that is faced in the UK. It has a long, very long history, trust me, I know, history with the mafia. But what happens is the UK has started having a very long history with kleptocrats as well. And kleptocrats are representing a danger to our national security, society, whatever you say. Crime in general, illicit finance, you know, fraud, for instance, is epidemic in this country nowadays. And I'm not even talking about kleptocracy, but it is an issue. So you need an appropriate response. And I'm not suggesting of, you know, bringing 70,000 officers as they do in the Guardia di Finanza, which is the, you know, law enforcement authority, but also tax authority and regulators, but at least to resource properly the NCA to bring some cases to court. You know, what we saw with the amendments in the Economic Crime Act, they were just a little tiny thing that, however, was trying to bring more cases, but we haven't seen any case yet, have we? So that's the point. Enforcement, look at the supervision. Kennedy talked about lawyers and, you know, the so-called enablers. Are they properly supervised? What are supervisors doing here? Sorry about that, Kennedy. I know that it's a, but you know, it's a series of reforms, and it's not just looking at the law. Reverse burden proof might help, coupled with other stuff.
Yes, I was going to come on to that issue about what are the practical steps that could be taken other than legislation with the mechanism we've already got. What could help? You obviously talked about resources there, recruitment and so on. Does anybody else want to talk about that? Again, you see this, Helen, you know full well that the cases aren't pursued because it's going to be too challenging, especially when you're up against people who've got very, very big resources that they can use to protract the litigation and run up very high costs. But would you like to say from your experience?
Absolutely. I always love talking about resourcing, because people know Spotlight loves talking about resourcing. I mean, I'd say two things. The one is, you know, and we see this in a lot of cases, as Kennedy's alluded to, you know, by definition, kleptocrats are pretty well resourced. They come with an army of lawyers, accountants. They can, you know, they're going to defend hard property. So you know, that's a given. So there's a kind of resource inequality. There's you know, in terms of prosecuting these cases and investigating. And I think that's one reason we need to resource law enforcement agencies better. But I think the other, and this is again on a more, to strike a more optimistic note or productive note, that is that I think it's a really worthwhile investment. I think law enforcement agencies consistently bring in far more than they cost. You know, I think every law enforcement agency, I have some figures that I think are very interesting for the NCA, which I think is probably most relevant for present purposes. Between 2016 and 2021, the International Corruption Unit recovered assets of over £400 million, which is over 10 times their budget over that 5-year period. So that's almost 1,000% return on their budget. I think we have to readily see that that's a very good investment to be made. So if we're thinking about the potential, you know, if you're thinking about the freeze to seize debate and looking at sanctions, well, a couple of weeks ago, OFSI announced in their annual report that £18 billion of Russian sanctioned assets are frozen here in the UK. I mean, the potential is huge. So I think surely investing in law enforcement to make sure that they can have the risk appetite, the ambition to go after what admittedly are very, very complex cases, I think is definitely the way to go. You know, it might not be as sort of sexy as finding new tools, but I think it's tried and tested. We know those are the problems that have plagued law enforcement, and I think we need to, you know, put our money where our mouth is, and enforce, you know, ensure that enforcement is well resourced and can be effective.
Kennedy? I mean, recruitment
I think
turnover
you
of
have to
staff
be,
and so on is another issue.
yeah, I mean, there's 2 points I would make. The first is you have to be quite careful. Helen's statistics are obviously correct, but I suspect the vast bulk of that 400 million is account freezing and forfeiture cases, which have got nothing to do with Russian oligarchs, and are based on the SAR system, whereby the police are given a SAR, and that is their starting point. They don't have to go out and investigate. In fact, they don't investigate. They sit in their office on the internet, building up a case, Googling stuff, and putting a load of material, which is usually junk, in front of the magistrate's court. And these aren't the type of cases that need the resources and the type of targets that we're dealing with. We're looking at the other part of the NCA statistics, which are what has been their success been in dealing with the Baker type case, the Hadji-Javid type case, and the civil recovery cases. And you'll see on average over the last 10 years that the recoveries have been between, is it 10 and 15 million pounds a year in civil recovery, apart from account freezing orders. And the costs of those kind of investigations are immense. So that's the first point. You've got to make sure you're comparing like with like when you're looking at resources. And I do think, just finally on that aspect, we're going to do this. I suspect that there's going to have to be some involvement of some kind of private sector commercial funding in order to fund these type of cases. And that leads into all sorts of policy difficulties about funders who are normally offshore entities benefiting from recovering the proceeds of crime. But I suspect it's not going to work, proper funding, without private commercial funding in the same way that one has in commercial litigation at the moment. And the second point I would make about resources is not just the money, it's the quality of the resources, as you touched on. Retention. I shall tell you a tiny little story. I realise we're running out of time. I only take 30 seconds. The last Russian case where I represented the target, I represented siblings whose father had recently died and left them £20 million odd. It came from a SAR. The police officer did his Googling, searched the internet. Our case was it came from our father's computer business, which he started in the 1990s. Obviously, the use of computers expanded greatly at almost exactly the time of denationalization in Russia. There's an enormous market for it. That's where he made his money. The kind of evidence the officer was relying on was there is nothing on the internet about these companies. Therefore, they don't exist. They don't have a credible representation. But he searched in English. He hadn't even bothered searching in Russian or the Cyrillic text. The company that I've identified, one of them is connected to a man who used to be Putin's chauffeur. You look at that in a bit more detail, and it turns out that it was a company with the same name, was the Putin chauffeur company, as the company with which my clients were concerned. He didn't know that in Russia you can have two companies with the same name, unlike in the UK. So the point I'm making is not just about putting money in and retention, but you've got to have people who are properly trained, who know what they're doing to investigate these type of cases. It's no good doing what you do at the moment, slinging a SAR at an officer in his office, telling him to get on the internet and build up a case. It goes without saying that that case was slung out of court and we got our costs.
And we're running very close to the Q&A session, but just one final point, just to get sort of loop back, I suppose, to the start of this. Why not link it all straight to the sanctions regime? If people can be designated under sanctions, can you address why that evidence itself couldn't be sufficient for doing the seizure bit as well?
Well, I think I kind of tackled this at the beginning. Sanctions themselves, they are a very political tool. They're based on a lower standard of evidence. They are usually based on intelligence that cannot be presented in court. If you are to confiscate, then you have to, go through better kind of evidence. I'm not going to use the proper legalese term, but I think you need to have sounder reasons to take somebody's property. And it's not just a matter of urgency. I'm conscious that the matter now that we're talking about, obviously there's some sort of urgency of showing that something is being done. However, right now is Russia, tomorrow it might be another kleptocracy. There are loads of other places, loads of other kleptocrats that are abusing the UK system, and they're not Russian. So the fact that we're looking at Russia now and that we're using sanctions, obviously sanctions, they respond to a foreign policy request. They seek to change behavior. That's their goal. And most of the oligarchs that we're talking about, they're not even on thematic sanctions, so anti-corruption sanctions, they're on Russia sanctions. We're talking about geographic sanctions. That's a completely different goal. If we're going to go after criminality, which is, I feel when we talk about kleptocracy, that's what we're talking about, then we need to talk about POCA, then we need to talk about asset recovery mechanisms, and we cannot use sanctions as a starting point for confiscation.
Anybody else, any thoughts on that? You would agree, Kennedy?
Well, I sort of agree, and I realise I've been very negative because we've been talking about trying to put what is a square peg of these people with this money connected to the Putin regime into the round hole of proceeds of crime. And in fact, it's in many ways its more natural fit is connected to regime change and association, patronage, potential use of funds, preventing the funds being used to undermine social order, all those kind of issues, rather than it being the proceeds of crime, which are more closely linked, to my mind, to sanctions purposes, notwithstanding the overarching principle that sanctions are to promote regime change. So what do you do when you've got the regime change and you've forfeited the asset? Do you give it back? You know, that's an obvious problem. But the problem, and I will be literally 30 seconds, the problem with appropriating and forfeiting people's property to the state, if it's not the proceeds of crime, is that you've got to have a proper legal basis to do that. And that's where the Human Rights Act comes in, which is obviously domestic legislation. For those who are listening online and may not know, it's got nothing to do with Brexit or the European Union. It's domestic legislation. And when it was brought in 1998, you may remember the minister promoting it. I can't remember exactly who it was, but certainly Blair said it amongst other people, bringing rights home. So these are rights which are enshrined in English law. And proportionality, I mentioned it before, you can't forfeit people's property which is disproportionate to your legitimate aims, which I just articulated. You need identification of legitimate aims, and then you can't make orders which are disproportionate to that. And also a problem is if you create a system whereby you take people's property away, and it's not because it's the proceeds of crime, then that looks a lot like a penalty. And it looks like a penalty for something which happened many years ago before you had the laws allowing you to forfeit it. And that creates what's called Article 7 retrospective difficulties. You can't penalise people for activity that wasn't a crime when they did it. Now, I'm not saying all these things can't be overcome. I think you could craft some legislation which does overcome it. What you can't do is tack this onto some other bill which is virtually through Parliament in a few clauses in the hope that it's going to stand up in the end to any kind of judicial scrutiny, because it isn't. This has got to be very carefully thought about, properly debated, and it has to go through Parliament with a great deal of care.
One quick point and then we'll go to the Q&A.
One very quick point. I won't rehearse the issues of retrospectivity and proportionality that Kennedy set out, but I think even if we see that sanctions may not be the best basis for confiscation in targeting the assets that we are, I do think that there can be better coordination between law enforcement and the sanctions regime. And I think we've seen that under the Russian sanctions regime, certainly in the first sanctions evasion case, which is going through the courts at the moment, there've been real difficulties that have been exposed, some teething problems between the NCA and OFSI to do with when licenses are issued versus when the NCA got AFOs against the corporate accounts of sanctioned individuals. So I think there are real concerns about how that coordination works. And just to take a step back from particularly the Russian sanctions regime, but if we look more broadly at the global anti-corruption sanctions, which are obviously very different, but I think what is so striking to me there is that, in fact, the sanctions regime really is moving in the opposite direction to law enforcement. The policy guidelines that go with the global anti-corruption sanctions regime say that if properties in the UK that could be subject to investigation, then it usually won't be the target of sanctions. So it's actually kind of moving apart, and I think we need to rethink that. I think that's a mistake. I think we should see these as working in tandem, and how can sanctions, for their own purpose and a different legal basis, but how can they reinforce as another tool, how can they reinforce law enforcement in the fight against dirty money? And I think, yeah, we need to be improving coordination on that front, and I think we've learned a lot in this year alone on that basis.
Okay, thank you. Questions? Anybody in the audience got a question?
Thank you, Martin. Duncan Hay, Transparency International UK. I think on kleptocracy, I share Maria's counsel of despair, but specifically on Russia sanctions. Yes, they're political, but they aren't arbitrary. Some of the entities on the Russia sanctions list are there because of their contribution to Putin's capability to wage war in Ukraine. When we speak of crimes, I think most people would consider a lot of what has been happening in Ukraine this year to be a crime. And there'll be people who will be talking about war crimes in particular, who think that what's happened just outside Kyiv. So my question to the panel is, can you envisage a situation where those who have contributed to Putin's ability to wage war in Ukraine are held in some way jointly liable for the harm done, and therefore seizing might happen as a means of contributing towards reparation?
Who would like to answer?
That's a difficult. You're now moving away from appropriating particular assets on the basis that they're connected to the commission of criminality, to imposing personal liability to account in a sum of money, which is calculated by reference to some system. In theory, there is nothing wrong with that, or plainly, all income tax systems work in that way, and you can make people liable to account. And I don't see any reason in principle why it can't take the form of a personal liability. It goes back to what I said earlier, though. We've got to be very careful to ensure it's a piece of legislation that's thought through, has proper legitimate aims which are set out in the legislation, is carefully crafted, and these have to be court determinations, not just administrative diktats issued by certificate from the Home Office or the Treasury or the Foreign Office.
I mean, I always say, people ask me this question, and honestly, I don't know how to answer, for the simple fact that I do not cover war crimes. I am not a foreign policy expert. I look at illicit finance, I look at dirty money. So for me, that's the goal. And obviously, if I have to think of Russia sanctions and the oligarchs, these two goals have mixed together and brought me in the conversation somehow, even though I would have never looked at war crimes before. And this was a conversation that I actually had with some US prosecutors, that they are going after the oligarchs and they're going after the assets. And the way that they were talking about this and how they were tackling the issue was, oh, our final goal, our purpose is to disrupt their lives. And then I was like, what about, holding them accountable for the specific crime? It's like, oh, that's not what we're trying to do right now. Right now, our focus is Ukraine. And as a result, we're going to halt their operations. They're going to make their life miserable. This is literally what they say. So you see, it's different purposes. And as long as kleptocracy is involved, as long as dirty money, then I can come back in the conversation. But that's foreign policy, so I stand back.
Yeah, very briefly, I'll be brief. I mean, I think it is perhaps slightly different to what we've been sort of focusing on in this panel, but I think it's a really excellent question. And I think, to focus our minds on the urgent need, I think, to resource the recovery and rebuilding of Ukraine. I think one of the challenges is linking individual conduct, those who are sanctioned, to the crime in this instance, if we're calling it that. So what is the link between an individual's property that we're looking to seize and that state's conduct? And I think the difficulty here is you have a minister's discretionary decision, effectively, that's being used, and perhaps a determination that a state has breached international law, international humanitarian law, as the basis for confiscation in court. And I think that the difficulty is, ideally, we'd want the court to be making that prior factual legal determination about an individual's conduct and their link to what's happened in Ukraine. And I think that's where the difficulty, it's about, for me, it's about the division of labor between what is executive decision, where there's a lot of discretion given. It is susceptible to judicial review. You know, you can challenge a sanctions designation, but it's not within the kind of control of the court in the way that asset recovery under POCA is. And I think that's the challenge, is how do we make sure that there are adequate safeguards on that determination of someone's involvement and they're linked to what's happened in Ukraine. But definitely I think it's a promising avenue, and I'd love to see sort of ambitious thinking and creative thinking about this within the constraints of it being legally sound.
Thank you. I'll take one from the online audience. Professor John Heathershaw, who I know looks at these sort of issues very closely, Professor of International Relations at the University of Exeter. It's for you, Kennedy. It's could Kennedy please explain the legal standard by which the links between Putin and many of the figures who've been sanctioned are, quotes, tendentious? Academic experts and researchers in Russian and post-Soviet politics have established exhaustively the origins of present-day kleptocracy in sources of wealth in the 1990s. Why is such expert witness testimony not more commonly used in court in civil recovery proceedings to prove the illicit origin of these assets? Would it work using their expert advice, insights?
Well, that's a fact-sensitive question. My experience of this is that I have never seen a proper expert's report put together for the authorities in relation to a Russian oligarch or alleged kleptocrat. I'm not saying that it isn't capable of being assembled, and I certainly have seen it in relation to, for example, a Nigerian local governor who was convicted in 2012 of money laundering in this jurisdiction. I should add, he still hasn't had a confiscation order made against him after 10 years.
James Ibori.
But I have James Ibori, you can look it up for yourself, it's well covered in the media. So it is possible to put together cases which are based on expert reports. The issue is whether the material is actually out there to support an expert being in a position to make an appropriate declaration, and it will withstand the scrutiny of examination by the other side and the courts.
And presumably, just one final point on that, just presumably also the fact that these people have obviously also got subsequently legitimate sources of wealth, which they can say were the source of the assets that they've got, rather than some other source. And that's often a problem, isn't it? That they've got two streams of wealth, at least.
A dozen streams
Yes,
of wealth.
yes. Could I, gentleman there in the audience, if I could ask you to ask a question, please, and I'll come to...
Hi, Duncan Adams, Head of Strategy. It was interesting to hear about the South African model in terms of racketeering, Italian model in terms of mafia, etc. Could the UK maybe take a slightly different look at how we perceive national security and some of the tools and mechanisms there? So, for example, we've reappraised over time what the agencies do. So they do more than just go for the traditional targets. They go for kind of some of the criminal targets. And then maybe around some of the kind of the SIAC type processes as well. That's a kind of a used tool on the immigration and counter-terrorism side, but could some of that toolkit be maybe expanded a bit? Just cool.
Does anybody have any thoughts on that? Helen, you want to?
Well, I'll attempt some of that. Yeah, I mean, I think there's definitely a lot of rethinking that we can do, and I think the discussion we had earlier about using national security and that as a framing, I think is a helpful place to start, is thinking of the ways in which illicit finance and dirty money in the UK really affects the system, the financial system, our political system, and I think readjusting the mandate of law enforcement and the tools that we have in line with that. I think that's definitely the way to start. I mean, I think it's quite a big question. I mean, there are many different avenues we can go, and I'm perhaps not best placed to think through all of that, but I definitely think that's the way that we should be shifting as a focus to what's the impact, and get to the root causes, but also the impact of it. Yeah.
If I may add to what Helen said, I think that one of the important parts of the racketeering laws that Helen explained, for instance, the one in South Africa, the same as for the Italian model, what these laws do is that rather than linking the assets of these individuals to a specific activity, they view them as proceeds of crime due to their association to a specific network. And that is groundbreaking. And I know that people have been looking, even just, again, the definition of kleptocracy as is presented in the US anti-corruption strategy, and then you compare it to how we would define grand corruption, for instance, or organized crime under the Palermo Convention. There are similarities there, and I think that there is worth to explore how and whether the link should be done. So obviously that's what the Italians have done, generally speaking. They're not tackling kleptocratic networks because that's not their major problem, although we saw the Sherazade being found in whatever it was, in the Tirreno Sea or whatever. But what they're doing is they're doing this thing against mafia members who are potentially in Italy as powerful as kleptocrats, especially in some areas, I might add.
Yes.
I'll just make one point, that is that legally it's very easy to get over any human rights concerns if what you're looking at is the proceeds of crime and you're taking it away because it is the product of activity which is illegal, because those are assets which the target shouldn't have in the first place. And so that is quite easy to satisfy the necessary tests as to proportionality and so on. If you're going broader than that, which you could, you're going to technically capture more, but you run into a host of arguments that you've got to deal with, mainly to do with disproportionality, which surrounds the idea that this asset has, ex hypothesi, been acquired illegally, but because, fill in the gaps, of some other bases, you're going to forfeit it. And the examples that one sees, for example, many cases in the European Court of Human Rights around failure to make declarations at the customs, where you've got an obligation to declare what you're carrying. That obligation is not complied with, but the money comes from a legitimate source. Many countries require those funds to be forfeited, and that's run into problems with the right to property because it's disproportionate to the commission of the criminality, which just relates to a failing to declare. So you've got, you run, it's not impossible, but you do run into some potential legal challenges.
If I could just switch hats for a second, your point about SIA, the Special Immigration Appeals Commission, where Shamima Begum's case has been this week, for example, I'm not sure that would add a great deal, because it wouldn't obviate the need to prove the criminal case if you were dealing with that, and if you were dealing with it about political links to the regime, unless it was an intelligence agency producing the evidence for that. Most of that is something which is in the public domain anyway, and as clearly we've seen, a lot of people have been sanctioned on the basis of those links, so to me it wouldn't seem to add anything. Anyway, I'm going to go back to asking questions. There's a question here online from Rob Byrne, who says, how strong a case could be made for confiscating the UK assets of a sanctioned oligarch should an enabler be found to be violating the law on their behalf by helping them maintain UK assets? Presumably sanctions breaching of some sort, of which there are one or two alleged cases, or cases of alleged sanctions breaches at the moment, in fact. But would that be feasible, or would that also encounter the same problem that you would then be, it would be disproportionate in the sense that the sanctions violation was a particular discrete crime in itself if proved, and the asset itself would be something separate?
Yeah, I think the Americans do this quite a bit. Sanctions evasions leads to forfeiture, and even the prosecutors who I've spoken to and the practitioners say that this is pushing it a bit, because you do have a causation issue. If I own an asset and I put it out of reach, then I haven't obtained it as a result of my crime of putting it out of reach in breach of sanctions. Have I retained it? No, not if it wasn't liable to be forfeited, but only I've only been able to use it rather than, which I have been, by evading a sanction. So the difficulties there come in identifying what property has actually been obtained as a result of evading a sanction. So you've got to reframe the law slightly to deal with that. And then you run into, as you've just said, Martin, some proportionality issues.
Just straight on that subject, I'll ask Helen or Maria, or both. Colin Nichols asked a question very much on this topic. Is the US having more success than we are in freezing and seizing the property of oligarchs and others, and if so, why?
That's one for you, isn't it?
I mean, again, it really depends on the test that we're talking about. If we're talking about sanction evasion, for instance, some cases have been brought forward already. One case is currently, I think, in court, but because there was one individual currently on US soil, and this is why they're bringing criminal charges of, I think it's money laundering, bank fraud, and sanction evasion. So I wouldn't say more successful. What they have been successful, at least in freezing, is that they definitely have been more capable of tracing the assets, or some of the assets that are out there. The UK has been freezing assets as well, in seizing and confiscating, not really, but I think again, it really depends on the purpose. And I think that UK policymakers have been smarter in a way in terms of waiting and seeing. And some sanction evasion, definitely Helen can talk more about what they've been doing with sanction evasion. And people, well, I don't know if naming the case, but yeah.
Sure. I mean, I think one of the interesting things is that it seems that law enforcement in the UK and the NCA in particular, the combating kleptocracy cell, is following a very similar strategy to the US in going after effectively sanctions evasion or attempted evasion as money laundering offences. And, you know, I'm no poker practitioner like Kennedy, but, you know, arguably I think you could be becoming party to a money laundering arrangement. And, you know, obviously the proceeds of evasion are the proceeds of crime, and seizing that way. I think purely the strategy there in the US and UK is that money laundering is supposedly easier, I think, to prove than prosecuting for sanctions evasion. So it's simply just the easier way of going about it. But I think that's certainly been the approach that we're detecting. However, as mentioned, there's, you know, one case going through the courts at the moment, which is, I think, a really important test case for the UK, and it really asking these questions, particularly, I think, interestingly, whether action taken to move money in anticipation of sanctions hitting is, you know, then becomes the proceeds. And you get into all sorts of interesting questions about, you know, what is the scope of the proceeds in that question, and then proportionality. So it's definitely going to be a key test case that I think will shape the strategy of law enforcement going forward. But at the moment, certainly from what I've looked at, it seems that the US and UK are taking similar strategies to this problem.
That's the Petraven case, if people aren't.
Petraven.
Yes, there are two people in the audience here with tied arms. This man, gentleman here, please.
Thank you all very much. My question is well, it's based on everything you've said, but largely to Helen Taylor's closing remarks in her main presentation about coordination. My name's Ewan Grant. I used to be the UK Customs Service's intelligence analyst covering ex-Soviet states. I subsequently worked in a number of European Union programs, including several times in Ukraine and Moldova, where due to very suboptimal practices in those programs, things which would have avoided the need for Howard Wilkinson to be the whistleblower at Danska were not action. So we needed Howard Wilkinson. My question is about international cooperation as the US gears up for its Kleptocracy task force going into operation in 2024. Do you see any signs of real proper preparation in the Ukraine across the board, including the private sector and banks, for trilateral cooperation, US, UK, and Europe? I say that because of very, very disturbing warning signs about the EU Anti-Money Laundering Agency. I've been calling this out for several years, and Andrew Churchill made a very eloquent warning last week. So is enough being done to prepare? Be afraid. Thank you.
Thank you. I'll maybe just take the other gentleman with a tied arm as well, because otherwise we'll run out of time. We'll try to address both points in the final remarks if we can.
Thank you for the information and the discussion. So it seems like we're talking about two things tonight. One is what do we do with the stuff that's frozen and that's here already, and the other thing is what do we do about potential future dirty money or alleged dirty money coming in, and what potential legislation could be made to affect either. So dealing with the future stuff, I think Helen made the point about various different things. I think you said party political donation scrutiny, but lots of others in the financial institutions target hardening as a general rule, and more due diligence, Companies House, all these places, and that's very valid. And it's those sorts of barriers, or the wall, whether it's at the border physical or in the border financial, whatever, that will prevent the future money being brought in, and then any misdeclarations or crimes detected, then that brings it into other areas. So that's the future side, and that should stand up to whatever regime it is. In terms of the money that's already here, I agree with Kennedy on this point that That's the whole point of money laundering. It happened 35 years ago. It's been laundered through the UK property market or whatever. It's essentially clean money now. And unless you've got proof of that crime back then, you can't do anything about it from a money laundering and by extension a POCA point of view. So your whole point of the evening about taking POCA out of it for the purpose of confiscating, you didn't sort of elucidate on the difference in burden between criminal and civil, which I think is relevant, and why potentially people look at POCA as a potential disposal, the balance of probabilities, so forth. But the question really is to Maria, the assets that are already here, why do we want to appropriate them? You know, what is the issue with them? So that's, if I could ask for a very short answer on that, why do we want to do it at all? And then I've got a potential solution, which I'd love to share with you.
Well, a very short answer, but I'm afraid we're going to run out of time. A very short answer to that one, and then somebody can answer the first.
I'm not a policymaker, so I cannot. That was exactly my question. We were in conversations for 6 months, I think, talking about freeze to seize, and then I think it was actually at a round table with Kennedy that the question came out and say, what are we trying to achieve? What is the ultimate goal? And again, it turns out that the goal was very different from units, for instance, in, I don't know, different departments even within government. So it's very important. I cannot answer the question. As long as policymakers answer this question, then we can potentially answer as well.
The solution to that, from my point of view, the reason why is because we don't want properties in London, in some cases part of our heritage, sitting empty for tens of years, gathering dust, all of this kind of thing, when these sanctions are still in place, same with boats in a harbour or whatever. So my solution that I like to do is to convert those physical assets forcibly into cash assets that can sit in a frozen bank account, and then we can reuse the vessels and the cars and the property, attracting interest subject to the freezing until those freezes away, because they're not hurting anybody sitting in bank accounts that are frozen. Whereas parts, big homes that are listed or whatever, that's a problem as far as I see.
Just would somebody like to address the first question, sorry, because we will be out of time. Kennedy or Helen?
Certainly, I'm happy to
Please,
give it
Helen, thank you.
You can add Kennedy. Yeah, perhaps to end on a note of optimism again, if just to keep the theme running. But I think sanctions this year and under the Russian sanctions regime has really brought to the fore the need for cooperation globally. I think it's been an unprecedented response that's required very close working cooperation amongst a number of countries, and you mentioned the US, UK, and EU. I think clearly that's the direction of traffic. I mean, even last week, I think it was obviously announcing an intention to work even more closely with OFAC in the US. So certainly on sanctions, I think there's really the need to work together and in tandem, and I think that's recognized, and that's where things are going. I think it would be great to broaden that out to law enforcement more generally. I think it is a priority, increased cooperation globally in the recovery of assets, knowing that, dirty money knows no borders. It doesn't abide by borders, and there is a need for cooperation. So I do think there is reason for optimism that in a way, what's happened in response to Russia's renewed invasion of Ukraine is really a wake-up call to both the absolute necessity, but also the potential of international cooperation. And I think there's a lot that we can build on there.
Kennedy, final thoughts?
Very interesting about purposing empty buildings rather than confiscating, so depriving people of their forfeiture rights and using them for the public good. It reminds me very much about 10 years ago, and this again, I promise you it's only 20 seconds, but I spent a bit of time in Serbia trying to help the government with their proceeds of crime and money laundering laws so that they could join the European Union, and I spoke to a woman who was called the seized asset manager. Whenever an organised criminal is arrested in Serbia, they immediately take away all their property before trial, and they repurpose it for libraries and hostels and whatever it may be for the public good. So I said to her, what happens if somebody is then later acquitted? And she said, well, that never happens.
Right, very good. A good note to end it on. Thank you very much to everyone. I think there's been a lot of interesting thoughts put forward, and clearly I draw from it that whatever legislation, if there is to be legislation passed to address this, Kennedy's point I think is a particularly strong one, that it really needs to be very clear, carefully thought through and withstand the actual day-to-day scrutiny of the courts, because otherwise it won't achieve the objectives that it's set out to do. But thank you to everybody here in the audience, for including those who've asked the questions, and thank you too to the online audience for their participation and for the questions submitted. Sorry to those who wanted to ask a question who didn't manage to do so, but hopefully there'll be something resulting from this down the line in Parliament and in law enforcement in general, perhaps.
And a paper
more
coming
work for
out in
Kennedy.
December.
Maybe.
Thank you.
Maybe.
Thank you very much.